Kirsten, are you at the computer?
I'm sorry, Brian, did you need me?
Oh, I was just checking to see if you were there and taking care of folks like Amber for rename and stuff like that.
I'm sorry, I'm talking to Marty. We just got the other YouTube meeting shut down.
Okay.
Started a new one with a new title for this. Doesn't prevent people from still getting in there.
Yeah.
And I don't have any way of viewing that meeting while we're doing our Zoom.
Yeah. No, I understand.
Okay.
I was just checking. There's going to be some folks joining like Amber who need to be renamed and things like that.
Okay. Let me I'm going to stop sharing my screen then with this and get people in if I need to. I see them.
Okay. Kirsten, I'm gonna let you go. You've been doing a great job. It's just you didn't know what was going on with YouTube and I needed to reach you. So
I don't know how to work on that.
The way it is and deal with it later.
Yeah.
So I see Mr. Stearns and Miss Jones. Thank you for joining. We're not live yet. Well, the YouTube stream is live, but we haven't called the meeting to order.
So Brian, as people come in, I get rid of the list of attendees. We had made a decision when we first started using Zoom that we didn't want that list of attendees to be broadcast. So once the meeting's up and running, the only thing I see are your photos up on the screen. I don't see the list of attendees or the phone numbers of the people calling in.
Okay. Yeah, we'll do a debrief after this. I apologize. I was overwhelmed by the technological challenges.
Okay. I think Gwen and I both started doing the same thing at the same time, unbeknownst to one another.
No, and that was super helpful. And that's Gwen and I actually chatted a few minutes ago. We'll talk about it in detail
Later. Okay.
I was stuck. The short thing is I was stuck doing things a certain way and didn't pivot to the way I should have been doing them.
I'm going to put the contact phone numbers back up on the screen.
Great.
Hey, Brian.
Yeah.
Did I hear you say you were having technical challenges?
Oh, I was just saying that facilitating a meeting like that is very challenging.
Got it. So I can feel good about my abilities to navigate. I appreciate it. Thank you.
Yeah.
Yeah, where do you learn stuff like that anyway? It's all trial and error, right?
Yeah. Yes. And in some cases, more error than trial.
Yeah. Well, I appreciate the way the mayor always makes that known.
Yeah. Scott or Tasha, can you hear me?
Yep.
I am, oh, there's Harry. That's what I was gonna ask about. Hello, Mr. Schneider. This is Brian von Lossberg. Hello, Harry. I can see you raising your hand.
Really? I can't see myself, but I can see you.
Oh, that's interesting. Yeah, we cannot see your video. We obviously have you with audio.
Huh. Well, I'm not good at this, but I'm trying to get the camera's, got a line through it. I'm trying to see if I can fix that. Oh. How about that?
I can see you.
Uh,
Brian, we're ready to go when you're ready to go.
Okay, thanks. Yeah, we can see you, Harry. Is there a way to tilt it? We're getting more of your ceiling than you. There you go.
Sorry about that.
Actually, maybe, there you go. You're good.
That's all right.
Yeah, thanks. Nice to see you, literally.
Good to see you.
And I want to make sure we've got, I see you, Tasha, you can hear us okay? Yep. And let's see. There you, I see you too. Okay, I believe, thank you, Mayor. I think we have everybody here. And it is a minute after 1. So I will go ahead and call Committee of the Whole, our second one for the day, to order. We don't have minutes to approve, and we'll do roll. Kirsten, could I ask you to call that?
Sure. Stacy Anderson,
Present.
Becerra,
Present.
Contos,
Here,
Harp,
Present.
Hess,
Present.
Jones,
Present.
Merritt,
Present.
Ramos,
I don't see Jesse in the meeting.
okay. Cheryl,
Present.
present. Vasika,
Present.
Von Lossberg, here, and West.
Present.
Okay.
Great, thank you. We also have Mayor Engen and Chief Administrative Officer, Mr. Bickle, joining us. And then we have Harry Schneider, Tasha Jones, and Scott Stearns from the legal team here. I want to mention, I apologize, forgot to mention, so we're doing our meetings virtually in response to the coronavirus. Right now up on the screen is some information about providing public comment for the meeting. There are a number of ways to do that. There are a few numbers up on the screen, several numbers up on the screen. I'll read the first one, which is 1-253-215-8782. Meeting ID is 960-049-3694. There's also an opportunity to leave City Council a voicemail at 406-552-6012. And then the council general email address that goes to all council members, council@ci.missoula.mt.us. And people are welcome to leave public comment on this agenda item or join us for public comment. I will check periodically during the meeting, and we'll attempt to take that public comment during the meeting. There's also a method to leave written public comment on a feature attached to the agenda item for folks. So by way of introduction, I'll just briefly say that it's been a while since we've had an update on water litigation. There are a few topics in there that I will let Scott, Tasha, and Harry outline. The one most pressing in my mind is what's going on relative to legal proceedings and arbitration, and understood that that had been impacted by the coronavirus situation in terms of timing. So, Mayor, do you want to say anything at the beginning here?
Pardon me, can we take the screen sharing down so I can see people? Thank you. Well, good afternoon and welcome. So our legal team is here to provide you a briefing. As Brian suggests, we had some bumps in the road as a function of pandemic, but team has been plugging away. We've had some scheduling issues, and in the meantime, I think the team is here to answer your questions and talk a little bit about the degree to which I believe that our case is becoming stronger by the day as a function of ongoing discovery through the arbitration process. And I'm happy to turn it over to those folks. Good to see you all today. And Harry in particular, it's nice to see you again, even virtually. And happy to hear what's happening in Seattle as well as Missoula as we march down a path.
Thanks.
Go
ahead, Harry.
My sense is things are much better in Missoula than in Seattle, so I'm happy for you. Our office has been closed, and we've been unable to enter our office since Friday the 13th back in March. We are told that we can start coming in maybe 25% of us at a time, beginning the middle of this month, but we're encouraged not to do so until the middle of July. So things are not good here, but I'm glad that they're better in Missoula.
Thanks. Scott or Tasha, who's kicking us off? Or Harry?
Oh, I can just bring you up to date on the schedule. We obviously started as scheduled this month with a 2-week hearing in Missoula with the 3-panel arbitrators because of the COVID-19 situation. There was really no opportunity to push forward, and frankly, I think we're better off because we've been continuing to receive late production of documents, which I do think strengthens our case greater than it would have been if we went to the arbitration hearing this month. Primarily because of the panel members, the 3 arbitrators' conflicting schedules, the best date we could get is January. We've got 2 weeks aside, January 11th through I think the 22nd, on the liability phase of the case that will occur in Missoula on those dates. And my sense is, even if some witnesses have to participate remotely, should the COVID-19 problem persist, I think the panel will go forward with that hearing for those 2 weeks. Side liability, and then if the city prevails on liability, there will be a separate damages hearing set aside for another week. I don't have that date in front of me, but Scott and Tasha probably do.
And would you mind even going back a bit further, Harry? I cannot recall, honestly, with some of the newer council members, how up to date they are relative to just, we had a scheduled hearing that was going to be here in Missoula. Could you kind of go back to the 30,000 foot level and outline that?
Well, once the panel was implemented and the decision had been made by the district court that certain claims of the city would have to be arbitrated, the panel set a case schedule which included deadlines for discovery, and that would be both production documents by both parties as well as depositions of potential witnesses and also experts. We were in the tail end of the discovery phase with a number of depositions having been taken and a number of depositions imminent when basically people were no longer able to travel, and we had a few witnesses who went into self-quarantine. That would have been in March, I believe, Tasha or Scott, and that was all headed toward a liability hearing that was going to start, as I recall, the middle of June, right about now. And that was stricken as a result of the virus. And so the schedule has been reset with corresponding deadlines for discovery and deposition, expert witnesses, and the liability hearing will commence with live witnesses or those that testify by video conference to a panel in Missoula beginning January 11th.
Thanks. And could I ask one of you to kind of speak through the way we have seen, just as a reminder for council and for the public, we've seen expenses come in associated with arbitration proceedings. This is being facilitated through the arbitration. I'm forgetting the name of the group, but it's the trade group or association, perhaps. But could one of you walk us through? My understanding is there are expenses associated with that. I believe they come through your firm, Harry, and then that's when we see them as claims here in the city.
Right. So the parties' letter agreement, which gives rise to the arbitration, provides that it will be conducted through the American Arbitration Association as administrator. Those services consist of identifying and impaneling the arbitrators, making arrangements for the collection of the arbitrator's fee, which are all on an hourly basis. And so we get a bill from the association for those costs. And you're right, my law firm has been advancing those payments, and then they show up as a disbursement on a bill from us. And those have, frankly, those have grown as the case has been litigated, primarily based on the amount of time that the panel has been required to spend on motion practice, on hearings, on briefs that they have to read, and on other tasks that we have really no control over preventing. I mean, it's truly the case that you can't control how much the other side is going to cause you to work. And they have not only caused your lawyers to work more than we ever anticipated, but it has caused the panel members, the three judges, so to speak, to spend time that I don't think any of them ever envisioned. It's caused the hearing to be extended by a week or two. It's caused them to spend time for which they bill. They send their time to the AAA, American Arbitration Association. They send it on to us.
And I want to make sure I'm not, I don't mean to be monopolizing sort of questions. So please, council members, if you have questions at all, go ahead and raise your hand and I'll call on you. You have mentioned, and the mayor mentioned, materials that I think strengthen our position through discovery. I'm guessing there's not a lot that you can say about that beyond that. But I want to at least give you the opportunity in case there is anything else on that topic that is worth sharing.
Well, I think if you're willing, I think that Scott or Tasha can give you sort of a general description of the impact of the information, even if we don't get into the specifics of it. Almost all of it is designated confidential, and some of it limited in to whom we can distribute it. But Scott, do you or Tasha want to take a shot at kind of an overall reaction to what we're seeing?
Harry's exactly correct. A lot of the documents and evidence that we've been receiving have been marked with various things like attorney's eyes only and confidential. Usually it's because it's the type of information that Carlisle would find very damaging to itself and its reputation. Harry's exactly right that they've put us through a lot of
I don't know, are other people having issues with the audio?
Yes,
Yeah, Scott, I think something just happened to your audio.
it might be.
Like Gremlins got it.
Yeah, that actually happened on our last call, Scott. So can you guys hear me okay?
Yeah, we can hear you okay, Tasha.
Let me
Good
just-
segue to you.
Yeah, well, he just passed me the torch, Scott, right here. So just to finish up on, I believe what Scott was going to tell you is that while we can't put up on a screen for you today the documents that we've received, they overwhelmingly make our case better than it was before. We came to you in the past with the opinions of the collective lawyers, and there are many that are working on this case, that the information that we received in the condemnation case made our claim here in arbitration extremely strong. The documents that we have received through this process, and some of it has been on an order by the panel forcing them to produce this information, has been extremely beneficial, and it has strengthened our case. And we are as comfortable as we have ever been proceeding to the hearing in January. There is going to be some work that will occur between now and then. Mostly it will be there are some documents that still have not been produced by Carlisle. There will likely be some additional motions that will be filed. But mostly we're going to have some depositions that need to be wrapped up. So as we were headed into the hearing set for June, we did have some depositions scheduled, but when things got shut down and some of those depositions were going to occur in New York, all of that went off the calendar. And so we need to get those depositions rescheduled. I would anticipate that that will happen in the fall. And then we will proceed towards the hearing in January.
And I think Harry covered this. The hearing in January is here in Missoula, correct?
Yeah, as the agreement of the parties requires.
Right. Stacy.
Thanks, Mr. Chair. So I was just hoping if it's appropriate, and you can deem this out of order question-wise, but I just, I think it would be helpful for the community and some of the newer members and myself as well, just to kind of have a quick refresher on why it is we're proceeding with this. What is the upside? I mean, we already own it. Most all of the already own the water company. Most of the judgments have gone our way. The judgment around property taxes went our way. What is the upside to the city, the citizens, constituents, water utilizers for us to continue down this? Why are we proceeding forward? I think would be helpful.
With the bad faith case.
Pardon?
With the bad faith case as distinct from what's been concluded with condemnation.
Thank you. Yes. Like, why are we still continuing on this, and how does it help, and how does it, if at all, does it fit into the bigger picture of the oh God, I can't talk that condemnation case. Say it quickly so you don't notice I can't say it.
Let me try to answer that, and of course my colleagues can chime in, and I hope they will. I recall being in front of the council in person back when we could do such a thing early on, and the origin of the case was basically described as follows. The condemnation was the pride. I mean, to be able to obtain ownership of the water system, I think was a great achievement by the city. And that was the most important thing. But then Mayor Engen and others asked, we had an arrangement with Carlisle where we were expecting that they would sell it to us without us having to go through the very expensive, very time-consuming, risky and uncertain outcome of condemnation. And of course, they fought it every step of the way, all the way to the Supreme Court. Several visits to the Supreme Court. And the question was, is there any way we can assert a claim to try to get back some of the money that we were forced to spend, not only in the increased purchase price that was the result of the condemnation valuation proceeding, above and beyond what the city understood would be the transacted price, and as well as the tremendous amount of attorney's fees, time, and expense, distraction that the city suffered as a result of Carlisle's refusal to do what the city understood would happen. And what the city understood would happen is that in return for supporting Carlisle's acquisition, which Carlisle needed that support in order to be able to convince the Public Service Commission that a out-of-state owner was appropriate. They wanted to buy the three operating companies by Western Water or Park Water, one of which was Mountain Water Company. The other two were in California. They were pretty candid at the time that their priority was the California companies where there was a drought, but they couldn't buy those two without buying the third. So a director of Carlisle knocked on Mayor Engen's door one day, said, "Hey, have we got a deal for you?" I'm paraphrasing, but basically, if you will support Carlisle's acquisition so we can buy all three, we'll turn around and make sure that the city is able to acquire Mountain Water within a couple of years. The city did what it was asked to do. Carlisle got approval. Carlisle bought all three companies. As Carlisle had insisted, the city waited 2 years until the former owner, Sam Wheeler, rotated off the Mountain Water Company board, Park Water Board, before it made its offer. The city made its offer, and Carlisle basically said, "Take a hike. We're not going to perform." Again, I'm paraphrasing, but that's what gave rise to the claim. And so after the acquisition was completed, job one, it was our advice that there is a way to try to recover some of that expense, some of that increased purchase price. And that would be to make a claim for Carlisle's bad faith conduct in not doing what the city understood it would do if the city supported Carlisle's acquisition. I see from my watch that's a longer answer than I intended and probably a longer one than you wanted, but that's my best effort to try to describe the history pursuing that.
I appreciate that, Harry. I think it was useful to recap through that. Sandra.
Yes, thank you. Earlier you mentioned that the reason why we haven't been seeing a lot of documents is because they are for attorney's eyes only. I was wondering if some documents if there's any documents that could be made publicly available or for city council eyes, just so we can get a kind of knowledge of the case as it proceeds. Or is that too costly and timely?
Well, I guess I don't have a perfect answer off the top of my head. The short answer is imperfect, but that is, yeah, there are some documents that are a matter of public record. Some of the documents were admitted into evidence in the underlying case, and those can be made available. And I also would add that there are representatives of the city who are entitled to see those documents that are sort of the highest level of protection. Isn't that right, Scott or Tasha?
Scott is nodding, and we're not going to acknowledge him because of his audio. Tasha is also nodding in the affirmative.
Yeah, certain decision makers were granted authority by an order to see documents, but it was a requirement by the Carlisle Group that documents that they decided to stamp, attorney's eyes only, would not be generally available. And the problem with the pleadings is that what has happened to date has been mostly about those documents and about expert testimony that is based upon those documents, which limits our ability to disseminate those types of legal documents, briefs, expert reports in a public fashion.
Go ahead, Sandra.
So since I'm new here, how would I go about looking at the ones that are publicly available?
So
jump to answer that, I'm going to ask Scott and Tasha and Harry to perhaps think about that and get back to council with perhaps an idea you can use me as a point of contact. We went through something similar with condemnation matter. And so I understand the request, Sandra. So is that a fair way to proceed, Tasha?
Oh, absolutely. That's more than fair for me. Thank you.
Yeah, Sandra, I would encourage you to read the complaint, though. I mean, I think which is a matter of public record. It is a very lengthy document, but it has a very detailed historical timeline and sets forth the factual basis for the claims, and that is an excellent way to start. There are some documents that we can gather. We would need to go about this carefully because Carlisle will take every opportunity to attempt to claim that we are disseminating information in violation of that order.
Okay, I understand. Thank you.
Julie?
I just wanted to say for Sandra's benefit, since she was not on council at the time, but in the past, Jesse Ramos did request access to documents, and that was, I believe, before our complaint on the bad faith case had been filed. So this was probably related to the condemnation case and some of the subsequent points about, paying for this or that. And Jesse was asked to sign a non-disclosure agreement in order to access those documents. He was not to do that. So there are, and others of us have been afforded the same opportunity. Wanted to see stuff. There just was things that still needed to be protected under a non-disclosure agreement. And so that's something that we perhaps have to give up if we want to see some of those documents, is that we have to keep them private. Thanks.
If there are not other questions on the bad faith case, there are a few other matters pending. I think I can think of one pending at the Supreme Court. Is there any kind of update on other legal matters that would be good to go over?
Tasha?
We are on appeal on one issue about additional interest and attorney's fees. The deadline for appeal, I think there's going to be probably a motion for an extension. So opening briefs will probably do about 40 days from now. Am I right about that, Scott? Nodding.
This is a very difficult environment for Scott when he can't speak.
Yeah.
Okay.
I would actually like to patent that technology. And I believe Tasha Jones would be a buyer of that product.
All right. No, I appreciate that. And if there is anything that reaches a decision point, we can obviously get folks back in for an update to council, which would be prudent. So I was unsure about the time to schedule for this. I fear I have overscheduled significantly. I mostly wanted to get folks apprised of the change relative to the arbitration matters that were happening in Missoula and got rescheduled to, it's hard to say it, but next year. I'm happy to take any questions from anyone else, or if there's any other input from the legal team. Oh, Dale.
We do have the Department of Revenue matter. Do you want to provide a quick update on that one?
I think we're looking to you, Tasha, because it's got audio.
I'm thinking about the Department of Revenue matter. I believe that we're awaiting a decision on appeal. Scott,
Yeah.
not on that.
Yeah, I think we're expecting it any day, essentially,
Yes,
right, from the Supreme Court.
Yeah. So we do know that it it went through the Supreme Court's panel discussions. And so, we could receive an order there literally any minute.
So
And
this,
tr-
so to be
traditionally-
clear, this was the decision that Judge Halligan made in her court and then was appealed to the Montana Supreme Court, and it involved the county and the Department of Revenue. We were also party to it, correct?
Correct. Regarding the reassessment of the allegation that property taxes should be reassessed.
Got it. Great. Dale, anything else from your point?
No, those are the matters. I think we've touched on all the matters that are outstanding. Happy to answer any questions as well.
Okay. Any questions from anyone else? Let's go ahead and put up, Kirsten, if you could, the public comment number. I don't see anybody in the waiting room. But if we could get that shared. Again, we have the phone number 253-215-8782, meeting ID 960-049-3694, council voicemail 552-6012, and the council email council@ci.missoula.mt.us. You can go ahead and take that down. Not seeing anybody in the lobby and seeing no more questions. Harry, it was nice to see you. Thanks for joining us. Scott will work on a microphone for you. And thanks, but thanks to you and Tasha. Appreciate the update.
Good to see all of you. Thanks for inviting me.
Yep.
Thank you all.
All right. Thanks.
Thanks, everyone.
I think you folks have about a half hour until our next meeting. Apologize for overscheduling.
It's okay, Brian. It's a tough one to figure out in advance.